Hello and welcome to Property Hotline on India's first property channel, Magicbricks Now. I'm Kavita Krishnan. Today we are answering all your legal questions related to property. So if you have any question, feel free to contact us. Contact details flashing on your screens. Our expert for the day is Hemang Jariwala. Hemang is an advocate at the Bombay High Court. He joins me in our Low Parel studio. Hemang, welcome to the show.
Thank you.
Let's take an email question first, Hemang. SS Verma has written in. Now, he says that his society permitted a family of 10 adults to occupy an 850 square feet apartment. Now, he wants to know if there's any limitation on the number of tenants who can reside in an apartment. That's a very interesting question.
Yeah, I agree. Basically, under the Cooperative Societies Act, a member has a right to occupy the premises, that is a flat. Now, it is the member who basically allows or sublets, his flat to some third party who would occupy the premises with the permission of the society. So here what is very important is that whenever a member is trying to sublet a premises, he should normally sublet it to a family and not convert that flat into a guest house. Right? The minute any person is trying to convert into a guest house, that is what society has to object to. Now, for example, in this case where the society has permitted a small flat to be occupied by 10 adults, right? So it means that it is converted into a guest house. So the society, such act is basically not welcome. A member has every right to basically go and approach a cooperative court, make the society also a party and the member also a party. In this case, who is the owner of the flat, wherein they can get an injunction to such type of occupation by so many people into a small flat, because not only the water consumption, but also because of their movement, there's a lot of nuisance which is created. And if there is too much of nuisance created by way of a guest house, then even the local police help also can be taken, because under the Police Act, nuisance also is a offence.
But Hemang, he very clearly says, Mr. Verma clearly says that it's a family of 10 adults. So I am presuming here that it's probably a joint family, and we know that Mumbai is a city of small spaces. It is not unusual, in fact, to actually find 10 people living together in an 850 square feet flat. People live in smaller flats for that matter.
Right.
So if it is a joint family, then what standing does Mr. Verma have?
No,
what complaint
if basically it is a family, joint family, welcome. There is not a problem. Then in that case, the society gets the 10% occupancy charges as per law. But then what has to be seen is that there is no nuisance created. As long as they are staying in a peaceful, harmonious manner.
What is nuisance? You're saying nuisance created.
Correct.
What qualifies nuisance?
See, nuisance could be fight amongst the family members in their apartment, creating a lot of noise and disturbance to the neighbors. Or what happens is that when there are too many people staying, they always tend to have some tiff with the other members who are very harmoniously living into a society. Because they are first of all not the members, they are not the owners. They know that they are here only for say 11 months or 22 months or a few months here. So they do not tend to be acting more reasonably and responsibly as is expected in a cooperative society.
But for all of this, he needs documentation to prove all of this, and he has to go to...
the minute there is a ruckus which has been created, if at all, if these people are not residing peacefully, following the bylaws and all what is required, then members, even if the society or the committee member is not taking any steps against them, individual member also has every right to approach a local police under the Police Act and book them under the nuisance offence.
Right. So, Mr. Verma, if there is nuisance being created, you can just go to the local police station and file a complaint. You will have to obviously give evidence of the nuisance, though. If they are creating a ruckus, you can go and file a complaint, and then the society will have to act on your complaint. Right, Hemang?
Absolutely.
Let's move on. We have Nitin Madlani, who's written in now. He says that he has a property in Mumbai in his name. He inherited it from his grandfather, who died in 1975. Now, there's an HUF in the name of his grandfather and his father, of which Nitin is a karta. Now, both his father and grandfather were not alive in 2005 when the Supreme Court had passed the order on HUF property where, girls or female children were given rights to HUF property. Now, sisters were married before 2005, he says, prior to the death of his father and grandfather. He wants to know if his sisters still have any right in this ancestral property.
See, let us make this point very, very clear, because there's been a lot of misunderstanding and whether the amendment is retrospective or not. 9 September 2005 is where the amendment took place in the Hindu Succession Act. The amendment very clearly read that if on 9th of September 2005, if the father and the daughter both are alive, then the daughter will be considered to be a co-parsoner in the HUF property, okay, and shall have equal share, like all other members of the family, to the HUF property as well as ancestral property. So if before 9th of September 2005, before the amendment took place, if the father has expired, then the daughter would not have any retrospective right in the HUF or ancestral property. So if 9th of September 2005, both the father and the daughter are alive, then the daughter, whether married or otherwise, will have every right in the HUF as well as ancestral property. One more important thing which has happened is that even the daughters, after the amendment, can become karta, which till now only the male in the family could become kartas. So this is one very additional point which has come up in the amendment, giving that status to the woman, daughter or sister to become a karta and run the HUF.
Right. So essentially, Nitin, your sisters, if we go by the question that you've sent us, you say your father was not alive in 2005 when that judgment was passed, when that amendment was brought in. In that case, your sisters really do not have any right in the property, though if you want to gift it to them, you are free to do so. However, key takeaway coming in here for all women who are tuning in to Property Hotline today, that is, after 9 September 2005, you have equal rights in inherited property, whether it is held under an HUF, which is a Hindu United Family, or whether it is something that you're inheriting along with your male siblings. Essentially, the woman can be made a co-parsoner, which means has equal rights in the property. The woman also can be made the karta of the HUF. The karta is the person who takes all the decisions in the particular HUF. Right? So that is something that you need to keep in mind if you are in the line for inherited property. Moving on, we have Rajesh Sanghvi now, who's dialed in from Goregaon East. Rajesh, what's your question?
Hello.
Yes, Rajesh. How can we help you?
Right. मुझे रीडेवलपमेंट प्रोसेस के बारे में मेरा क्वेश्चन है.
हाँ जी, बताइए.
एक्चुअली 2010 में हमारा सोसाइटी ने एक बिल्डर को अपॉइंट किया है और अभी 2016 चल रहा है. अभी उसमें मेरा जो प्रॉब्लम ऐसा है कि अभी मैनेजिंग कमेटी ने MOU पहले साइन किया, आफ्टर दैट डेवलपमेंट एग्रीमेंट साइन किया, बाद में डेवलपमेंट सप्लीमेंट्री डेवलपमेंट एग्रीमेंट साइन किया, बाद में पावर ऑफ अटर्नी किया. लेकिन वी आर 80 मेंबर्स, 80 फ्लैट सोसाइटी, और उसमें 30 मेंबर्स हम लोगों ने हमारा कंसर्न दिया नहीं है, बिकॉज हमको बहुत इसमें इरेगुलरिटीज लग रही है. अभी ये सिचुएशन में प्रॉब्लम है, और डेवलपर्स ने और कमिटी ने सब हमारा जो बाउंड्री है सोसाइटी का कंपाउंड वॉल, उसमें 3 शीट्स लगा दिए हैं और कंटेनर साइड कैबिन भी इंस्टॉल किया हुआ है, और प्रोसेस एज इट इज है. अभी हम लोग 30 मेंबर्स ने कंसर्न दिया नहीं है, अभी वो 42 मेंबर्स का.
तो राजेश, आप बेसिकली ये जानना चाहते हैं कि अब आगे आप लोग क्या कर सकते हैं?
हाँ, क्या कर सकते हैं, प्लस ये सब 3 सीट सब लगा के कवर कर दिया है. अभी हम लोग हमारे मैक्सिमम आउट ऑफ 80-55 मेंबर्स तो स्टे कर रहे हैं सोसाइटी में, और हमको ये सब क्वेरी है. हम BMC में, MCGM में सब जगह पे कंप्लेन करते हैं. तो डेवलपर्स अगेंस्ट BMC हाई कोर्ट में केस करते हैं. तो ये सब हम लोग इसमें थर्ड पार्टी में हम लोग सब मिस, हमको कोई मिल नहीं रहा है.
जी राजेश, हेमांग से पूछ लेती हूँ. हेमांग, क्लियर लॉ है कि आपको कम से कम 75% यानी 75% रेसिडेंट्स का कॉन्सेंट ज़रूरी है अगर बिल्डिंग को रीडेवलप करना है. तो यहाँ पर इनका कहना है कि आउट ऑफ 70 30 रेसिडेंट्स है जिन्होंने मना किया है, जो नहीं करना चाहते रीडेवलप, तो फिर ये आगे कैसे बढ़ सकते, क्या करें अब?
राजेश जी, मुझे पहले ये क्वेश्चन आपको पूछना है कि आपकी जो सोसाइटी ने रीडेवलपमेंट का जब डिसीजन लिया, तब जो पहली एसजीएम बुलाई जाती है जहाँ पे 75% की कंसेंट ली जाती है और फिर वो एसजीएम बुलाई जाती है, तो वो एसजीएम बुलाई थी क्या?
नहीं सर, इसमें ऐसा है कि ये सब पर्सनली मेरा तो कंसर्न नहीं है और मैं इसमें मुझे कोई डिटेल्स जानकारी नहीं है सर, क्योंकि हम लोग 30 मेंबर्स हमारा पहले से ही ये प्रोसेस में इरेगुलरिटीज से हमारा ओपोज चल रहा है।
नहीं, तो मैं ये समझ रहा हूँ राजेश जी कि आउट ऑफ 80 30 लोगों ने कोई चीज़ में कंसेंट करी ही नहीं है।
हाँ, करी नहीं है।
तो जब 30 लोगों ने कंसेंट करी नहीं है, तो 79A में जो डेप्यूटी रजिस्ट्रार अपने एक आदमी को भेजता है एक मीटिंग कराने के लिए सोसाइटी में, जो वीडियो कॉन्फ्रेंस के द्वारा होता है या जो प्रोसीडिंग्स वीडियो होता है, पूरा वीडियो रिकॉर्डिंग होता है, तो वैसा आपकी सोसाइटी में मीटिंग रखी थी?
नहीं सर, इतना ये जो डिटेल्स है आप 75% की, वो तो मेरे नॉलेज में तो नहीं हुई है।
नहीं, तो जो 75% की कंसेंट नहीं हुई है, 79A में जो परमिशन मिलनी चाहिए डेप्यूटी रजिस्ट्रार से वो जो मिली नहीं है, तो सोसाइटी को कोई भी अधिकार नहीं है डेवलपमेंट अग्रीमेंट को एग्जीक्यूट करने का, एमओयू साइन करने का या पावर ऑफ अटॉर्नी देने का कोई भी बिल्डर को।
पर ये कह रहे हैं कि ऑलरेडी काम शुरू हो चुका है, पत्रा लग चुका है,
Correct.
तो अब राजेश क्या कर सकते हैं?
आपको बेसिकली आप जो है एक क्लास सूट फाइल करिए अगेंस्ट दी बिल्डर, जो भी प्रपोज बिल्डर है या जो भी बिल्डर बोल रहा है कि अभी ये अग्रीमेंट मेरे साथ हो गया है, सोसाइटी को और बिल्डर को दोनों को आप पार्टी डिफेंडेंट बनाइए। आपकी वैल्यूएशन 1 करोड़ के ऊपर है, यानी ऑनरेबल हाईकोर्ट में जाइए और वहाँ से इंजंक्शन लीजिए कि ये जो भी डेवलपमेंट की बात कर रहे हैं, जो डेवलपमेंट प्रोसेस की बात कर रहे हैं, वो एज पर लॉ जो भी होना चाहिए, 75% की कंसेंट लेनी चाहिए, 79A में डेप्यूटी रजिस्ट्रार का जो ऑर्डर आना चाहिए, जो टेंडरिंग सिस्टम होना चाहिए, जो फिजिबिलिटी रिपोर्ट निकलनी चाहिए, ये रीडेवलपमेंट में सोसाइटी ने कहीं पे भी किया नहीं है। इसके लिए कोई भी तरह से ये बिल्डर डेवलपर या कमेटी हमको फोर्स ना करे अपनी जगह छोड़ने के लिए, तो आप तुरंत जाइए और ऑनरेबल हाई कोर्ट में ये केस दर्ज कर दीजिए।
तो राजेश, वेरी सिंपली आपको यही करना है कि आप सोसाइटी और जो सोसाइटी मैनेजमेंट है और जो डेवलपर है उनके खिलाफ एक केस दर्ज कीजिए हाई कोर्ट में, क्योंकि 1 करोड़ से ज़्यादा का आपका मामला है, और फिर हाई कोर्ट से ये मांग कीजिए कि वो जो भी काम हो रहा है, जो कंस्ट्रक्शन हो रहा है, उस पर स्टे लगा दे, उसे रुकवा दे, और उसके बाद आप अपनी केस जो है वो आगे लड़ सकते हैं। आप ये प्रूव कर सकते हैं इनफैक्ट कि ये जो भी एक्शन
कोर्ट से वो डायरेक्शन भी लें कि भाई ये जो भी मैनेजिंग कमेटी है वो एज पर लॉ महाराष्ट्र कोऑपरेटिव सोसाइटीज एक्ट में 79A का जो भी प्रोसीजर है वो कमेटी को रीडेवलपमेंट के लिए कंप्लाई करना ही चाहिए।
Tell me something here, Hemang. Can he also ask? Can this group of residents also ask for the society to be dissolved, the managing committee to be dissolved, because clearly they are going against what the majority want over here.
Oh, that is also a possibility, but basically the High Court would normally not interfere into the internal working of the society. No doubt here, prima facie ये दिखता ही है कि मैनेजमेंट हैंड इन ग्लव हो गई है डेवलपर के साथ, और इसके लिए ये सब डेवलपमेंट अग्रीमेंट वगैरह सब उनके साथ एग्जीक्यूट हो रहा है। मगर हाई कोर्ट से एटलीस्ट अंडर एन ऑब्जर्वर ये आप मांग कर सकते हैं कि एक ऑब्जर्वर दीजिए, और ये जितनी भी 6-7 एसजीएम बुलाई जाती है वो सब वो ऑब्जर्वर के अंडर में एक ट्रांसपेरेंट तरीके से ये पूरी प्रक्रिया होए।
राइट राजेश, आई होप वीव आंसर्ड योर क्वेश्चन देयर। उम्मीद है आपको जवाब मिला आपके सवाल का। अगर आगे कोई भी दिक्कत हो तो ज़रूर फ़ोन कीजिएगा, और हमारे जो लीगल एक्सपर्ट्स हैं आपके सवालों का जवाब देंगे। राइट, थैंक यू वेरी मच। Let's move on and take Sarfarosh Rathod's question now. He says that he stays in a multi-story building in Pune. Now, 2 members of the society are conducting their business there. Now, they've established their offices, they have staff reporting on a daily basis, clients frequent their office. Now, he wants to know if a residential apartment in a cooperative housing society can be used for commercial activities. If not, what remedies are available to him? You have to take the permission of the housing society, right? Before you go ahead and do something like this?
Yeah. Here, basically, the issue is that there is a complete change of user. What is permitted under the DC rule is basically 1/3 of the total area of the residence, which can be used for professional basis. Right? If a professional is residing in that premises, say 1,000 square feet, 300 square feet can be used for his office, wherein he can have his own study room, or he can call his client and he can entertain that. But he cannot convert the whole 1,000 square feet into an office, have his own staff sitting in the complete premises, right, and thereby convert the residential into a commercial, which is not permitted under the Maharashtra Cooperative Societies Act. It is also not permitted under the MMC Act, because under 342, change of user is also an offence, and the DC rule permits only 1/3 in case of professionals.
So essentially, Sarfarosh, if there is more than 1/3 that is being used as an office, which seems to be the case as far as you are concerned, then you can actually seek legal recourse. What can he do now?
No, as regards the society is concerned, and if they are going through this, they can approach directly the consumer forum, because the cooperative society very well comes under the consumer forum, because the very fact that when you are paying maintenance.
Hemang, I refuse to believe that something like this can be happening for any period of time without the society or members of the managing committee actually knowing about this. Obviously, it's happening out in the open if there are clients, etc., coming over here.
Right.
And there would be some society members who are, who are all for it.
See,
in that case, what does he do?
Normally, what's happened is that the society takes a recourse by charging them double of what is the amount charged as maintenance to the residential, and that is where majority of the members are comfortable. That okay, if we are paying 10,000, the commercial people are paying the 20,000 per month as maintenance charges or whatever that charges are, right? But in case where these certain members who are disturbed, okay, because of all these activities which are being carried out, then their recourse is always there before the consumer forum, wherein the law does not permit change of user. Whether he pays double the maintenance or otherwise, important here is that the activity which is being carried out, and that to 100% commercial, tantamounts to violation of the bylaws as well as the MMC Act and the DC regulation, and hence this activity has to stop.
So essentially, Sarfarosh, you can begin by sending a legal notice to the people concerned and approach the consumer forum, file a case if they do not respond, and get your peace of mind, fight for your peace of mind.
They can also take the matter with the concerned corporation.
That's also there, because they are in fact changing land, or in a way land use, change of use. Right? So you can also take it up with your local body, your local ward office. That is where you should be complaining. You should also be complaining in the consumer forum. Hopefully that should give you some peace of mind. Let's take an email query now. Jitendra Gaur has written in. He says he's in the process of selling his flat. He's received 40% amount from the buyer. Now the buyer's lawyer is asking him for the original documents. Once Jitendra submits it to the lawyer, they will give him a receipt, post which he'll get the remaining 60% amount via RTGS online on the day of registration. He wants to know if he should give his original document to the buyer's lawyer. He asks whether he has any other option. Should he be doing that, or shouldn't he ideally get the entire sum in one hand and then give the...
My advice would be, sir, do not let go of the originals at any cost. You have already got the 40% with you. Please tell him that if he wants to have a look at the originals, he is most welcome to come at your office or residence, wherever you are, and in your presence, he can definitely vet the original documents which you are having. At the most, if he wants, you can make a photocopy and keep it ready. So after he has gone through the originals, hand him over all the photocopies, and once the balance 60% has come to you through RTGS and the document is duly registered, right? Thereafter, along with that, you can hand over all the originals to him with a covering note, so that the deal is complete in all respect. But before that, do not hand over a single original document.
Right. So that's another key takeaway coming for all you viewers of the show. If you are selling property, ensure that you hand over documents, original documents of the property only once you get the entire amount for that property. Do not hand over your original documents unless you get that entire amount. You can give them, if the buyer wants to check the documents, you can always give them a copy of the documents. You can ask them to come to your house or office and see the originals, but do not hand it over unless and until you get the entire money in your hand. Next, we have a caller who wants to stay anonymous. Tell us, how can we help you?
Yeah, good evening.
Good evening.
I have bought a property in 2009 in Thane, and from my relative. And when I bought, the parking lot was also included in the sale deed, and that was also included in the first sale deed with my relative and the builder.
Okay.
After buying the property, I was out of town for some time, around 6 months. And when I came back, I saw that on my property, the society has built up their office.
Okay.
And so what legal actions I can take? Means I have lot many times wrote them letters, but they say the second-hand buyers don't get the parking space. It is as per law. There is some law. There was no clear...
Right. Tell me this, is that parking lot mentioned in your agreement, the one that you got from your relative?
Yes, it is very well mentioned.
And the builder is your relative, you're saying?
No. The builder had the first agreement with my relative.
Okay.
And then I took the house and the parking from my relative.
And have you registered this agreement?
Yes, it is registered.
It is registered. So he has a registered agreement, Hemang, which shows that the parking lot belongs to him. But in case of resale, what happens? Does it really go to the buyer, or does it revert back to the society?
See, basically the society taking away this gentleman's parking area and first of all constructing a society's office itself is illegal, because the approved and sanctioned plan would always be showing his area as a marking of car park. So first of all, a car park, open car park space has been converted into an office, which is absolutely illegal and unlawful, absolutely violative of the approved and sanctioned plan. So first you have to shoot a legal notice to the society stating very categorically that first of all you have taken away my open car parking space, and on top of that you have constructed an illegal and unlawful society's office, and therefore kindly demolish the same and hand over the open car parking space to me. Right? The society would not be doing that for obvious reasons. You kindly thereafter take the matter up with the local Thane Municipal Corporation, pursue the matter with the ward office and the assistant commissioner there, and if need be, even after making complaints with the corporation, if the corporation is not taking any steps, then kindly file a writ of mandamus before the Honorable High Court for a direction to the corporation to break this illegal and unlawful structure which has been constructed by the society. That is point number one. Point number two is, under the Maharashtra Cooperative Societies Act and the bylaws, 78 categorically says that every member who has a car park should be given a car parking allotment. So irrespective of whether you have purchased the car park or whether the car park is mentioned in your agreement or not, if there is open car parking space, then the society is duty bound to give you an open car parking space as long as you are having a car which is owned by you or company has given it to you. So this is a second important thing. Third is that once a builder has allotted, because a builder cannot sell open car parking or stilt car parking, because there is a Supreme Court judgment of Naharchal Naluchar, because car parking space do not consume FSI, and hence the builder cannot sell. In your case, the builder has allotted to your relative, and the same agreement has been carried forward between your relative and you. So what is there is an allotment of car parking space.
Right.
Right. So same thing, you are protected by the Act. Under 78 bylaws, you are supposed to be getting.
Essentially what Hemang is telling here is that you have a right to a car park, whether or not, whether you bought it in a primary sale, whether you bought the flat in primary sale or whether you bought it in secondary sale, if you are a society member, if you have a car, the society is duty bound to give you a car park. So go ahead, take the necessary legal recourse. You can approach the municipal corporation over here. You can also approach the court if the municipal corporation does not listen to you. So key takeaways, we are nearing the end of our show and there is a lot that we've learned today. One, of course, is what we just learned, that if you are a member in a housing society and you own a car, you have a right to a car park. The society is duty bound to give you a car park. Second, another big thing that we've learned, and this is for all our women viewers out there, after September 5, 2009, you are guaranteed equal rights in a property. This is a property that you inherit, whether you are inheriting it with your siblings or whether it's held under a trust as in an HUF, a Hindu United Family. You have equal rights over there. You can be the co-parsoner of the property, which means you can get equal share in the property. The woman can also be made the karta or the decision maker of the HUF. And the last and final important thing that we learned, do not hand over documents of your property without getting the 100% sale amount if you are selling property. With that, we've come to an end of today's episode of Property Hotline. Thank you very much, Hemang, for coming in, for answering all those questions. And if you have any questions related to real estate, it could be anything. It could be buying, selling, investing in property, legal issues of the kind we answered today, taxes related to real estate, or home finance queries. Get in touch with us. We'll get the country's top experts to answer each and every one of them. Thank you very much for tuning in. Keep watching Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at Magicbricks Now. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.